so as to establish that.
Correct, my lord.
That the fixation of royalty is itself inclusive of all taxes, state
And
taxes.
nothing more.
That's one. Second, your argument that, well, it's desirable that there should be uniformity of the price of minerals. It may be a desirable argument, it may be a desirable matter as a matter of policy. Question is whether this will impinge upon the federal distribution of power under the Constitution. Now, take another case. Look at, there's several taxes the states can levy under the state list.
My lords.
I'll just give you two examples. Entry 53 of list 2, taxes on the consumption or sale of electricity. Right? Now, in various industries, electricity is not just a medium, but it's a raw material. For instance, in the production of steel, iron and steel industry, electricity itself is a raw material.
It's part of the price structure also.
Right. And now the Constitution contemplates that each individual state can levy a tax on the consumption and sale of electricity. Now, different states levying taxes at a different rate on the consumption and sale of electricity will meet with the same argument that you are urging, that in Maharashtra may impose it at a different rate, Karnataka may do it at a different rate, a solar plant in Rajasthan may do it at a different rate. But that's part of the federal scheme. Or take entry 54,
right.
Taxes on sale of petroleum crude, high-speed diesel. High-speed diesel is crucial for industry, motor spirit, natural gas. So if you are consuming natural gas from, say, which comes in from Jamnagar, different rate altogether. If you are importing natural gas, which has come in through, say, a crude pipeline, a gas pipeline, say, in Chennai, completely different rate. That's exactly the scheme of the Constitution. That and there is nothing sui generis about minerals, that there should be a uniformity. Then the same logic will apply to electricity. Have the same rate of electricity, same taxes for electricity.
Ignore that example and I'll give the answer. In other entries like electricity or entry 54 list 2, there is no provision like entry 50 that's subject to limitations placed by the parliament under 54.
But therefore, there is a safeguard. Suppose, say, Jharkhand places taxes at the rate of 500%.
Ignore that example. I'll make it good on other.
Suppose some state levies rates at the rate of, say, 300%, something disproportionate, which will really affect the industry. And that state is a primary source of that mineral in India. Parliament can certainly regulate the rates. When you are prescribing limitations, you can say that, look, rates will not exceed so and so. Rates on this mineral will not exceed so and so. You can have differing limitations for differing minerals.
So please ignore that example for the time being.
Union has not thought through how they can use the limitation power, imposing power, to ensure that where the states are not restricted in imposing taxes, the taxation structure in the states does not affect overall the development of the mineral or the development of the industry. Parliament can still do it. But they'll have to do it then in a nuanced case by case, mineral by mineral basis.
My lord, that is where, my lord, we would respectfully, my lord, argue that MMRDA is that restriction. What is the Constitution says limitation on? Well, this is sui generis for the simple reason. This is the only entry, taxing entry, which is made subject to some other entry. There is no other taxing entry. Number one. Number two. In
but
case of
made subject to the other entry, it's made to subject to limitation in the interests of regulation and development of minerals. So it's quantified very carefully. Mr. Salsara, if you want to sit for a minute, sit.
No.
The limitation is a constitutional limitation. It is not any kind of limitation.
Exactly.
So a constitutional limitation has to be read in the context of Article 265 of the Constitution.
And that too in public interest.
Because there can be no taxation except with authority of law. So a constitutional limitation to tax juxtaposed with Article 265 must be the
correct, my lord. I bow down.
interpretation.
I bow down. Second, as my lord,
I think you have to answer. You are banking upon the fact that states have say in determining royalty. There you may not be right. Under section 9 subsection 3, it is the exclusive power of the central government to decide what is the royalty. States have no power, no read section 9 subsection, the exclusive domain of the central government. States do not have any say in fixing royalty.
If your lordships can, my lord, consider, my lord, allowing me to develop
We
further.
are just pointing out so that you can answer.
Certainly,
it
my lord.
in
I'm
appropriate
conscious of the
Right.
fact that the consultation is not statutorily contemplated.
That's
That's
right.
what, my lords are very rightly putting it to me. But the consultation is read in every provision. That's what I'm going to show. My lord, please take my written submissions, my lord.
Where do we get them,
My lord, volume 2F. And my lord, I will ignore whatever is argued or whatever may perhaps not be relevant immediately.
Volume?
2A.
2F.
It should be two
2F, my lord.
E.
No, it is thereafter changed. No, there was some mistake at night, my lord.
We should ignore E.
Yes, my lord. Please ignore it, my lord,
Okay.
and if possible, delete it, if it is possible to delete. Annexure was wrong, my lord. Instead of the report of 2019, the report of 90 was annexed. Now, there was
Got-
nothing to hide in there, but that was no relevance of that.
Got it.
Page 5, my lord, page 4. PDF 5, I'm sorry. PDF 4. my lords. I'll, my lords, keep what is not relevant, but what is relevant, please allow me to, my lord, read. My lord, this history relates back to the industrial policy. I'm not reading it. I'll just, I have annexed, my lord. Lord, Lord, historically, my lord, immediately, not immediately, but sometime after independence, my lord, we declared our industrial policy, my lord. First was 48 and thereafter 56. I have annexed it for your lordship's reference and record, but I'm not going to read it. My lord, the intention to place this is this, my lord, that the nation for the first time decided how our industrial growth will take place, what would be the roadmap. And there, they divided certain sectors in Schedule A, Schedule B, Schedule C, and Schedule D, where core minerals were placed in Schedule A because they are directly or indirectly responsible for industrial growth of other industries. That's the purpose. Lord, please come to, my lord, PDF 6, my lord, para 4, PDF 5, my lord, I'm sorry. PDF 5, para 4. I'm sorry. Okay, this is wrong. I'm sorry. My lord, PDF 6, my lord, I am, as usual, my lord, behind the rest. Para 4, my lord. The Industrial Policy Resolution 1956 put major minerals such as coal, lignite, mineral oils, iron ore, copper, zinc, atomic minerals, etc. in Schedule A, which was reserved exclusively for public sector, and minor minerals in Schedule B, which the private sector was allowed to participate in mining activities. Your lordships can, my lord, thereafter come to page 5, para 5. The minerals available in the nation are naturally finite and are perhaps the most valuable resource for the development of the country. Minerals are the vital raw material for the core sectors of the economy. The exploration, extraction, and management of minerals have to be guided by national goals and perspectives to be integrated into an overall strategy of country's economic development. The endeavor shall be to promote domestic industry and reduce import dependency, which make domestic industry resilient and self-sustainable. This is the difference. In other cases like electricity, etc., we don't have to see the global market. There can be, my lord. And please, my lord, for the time being, my lord, allow me to say, please don't treat this as a federal issue. There is no state versus center. It is the state government which collects everything only for the reasons which will follow. The price, the royalty fixation, the quantification is done by the center, keeping the global phenomena and the domestic scenario in mind. Then your lordships may come to, my lord, 7, para 8. This is, my lord, more relevant, my lord, why, to answer, my lord, the Chief Justice of India's query, my lord, why mineral stands on a different footing and why its fixation of everything which is to be extracted from whoever is liable to pay is to be federally governed, my lord, if I may use that expression. 8. The mining sector and extraction of mineral by the very nature of the subject requires to be taken up holistically at a national level, as its regulation and development shall have to be based upon the following. My lord, please see each one of them, my lord, carefully. National landscape for protection, exploration and extraction of mining. Mineral being a national wealth, its distribution for the benefit of every citizen of each state as per principles of socialism enshrined in the preamble. Then 3, impact of high burden of levy on Indian minerals in comparison to international mining jurisprudence. Look, this is crucial. Look, if high burden is put on each mineral, my lord, by different states differently, we may not be able to, my lord, deal with the global situation. Lord, 5, my lord, 4 is really, my lord, crucial, according to me. I'm sorry. Lord, your lordships, when examines, my lord, the interpret the entries or any constitutional principle, the lordship would examine, lord, would keep in mind these factors because these are in public interest as envisaged under 54. But let me, my lord, proceed, my lord, rather than, my lord, para 4. My lord,
Parliament can always say, by prescribing limitations, apropos your submission, we understand the policy issue in the submission, but Parliament can always say that, look, the carrying cost of this particular mineral should not exceed a certain amount. So then you can indirectly ensure that the
Lord, that
tax
is said,
structure
my lord,
also
if your
doesn't
lordship-
out of hand.
Lord, that is said. That is said, I want to show that. If your lordships can, my lord, just bear with me for some time. I'm just giving the justification for it. And, my lord, this is my answer that the architecture itself is a limitation. Please see, my lord, 4. And this is, my lord, really crucial for the nation. Dependence of, and for the time being, your lordships may, my lord, consider, put, my lord, these 2 entries on the side. Just examine, my lord, the bare situation, my lord, which the country is dealing with. And thereafter, I'll come to 2 entries and how the law has taken care of. dependence of imports for certain minerals and regulation of exports of domestic minerals, use of which is needed for the core domestic industries. Now, please note this, Manoj. The import and export is mostly based upon the comparative price fixation in domestic as well as global market. And such price fixation shall depend upon the levy of royalty and others imposed on each mineral in India. Lord, meaning thereby, if we overtax a particular mineral, my lord, suppose some mineral is, my lord, available only in 2 states, it is overtaxed, then the domestic industry in rest of the India would go for importing the cheaper mineral from the other countries. This has a direct national impact. Then 5, the national concern about growth of mineral sector at a national level so as to ensure that share of mineral industry contributes in the country's GDP. But when we say that we have a law for regulation and development of mines and minerals, we also mean that we want it to regulate and develop in such a fashion that it contributes to the GDP as a sector, not state-wise. Then 6, the fixation of consolidated amount like royalty, etc., at a national level for each mineral will ensure availability of domestic mineral at a reasonable price as compared to international prices. Separate levy regime by mineral-rich states results into disparity and high cost of domestic production, leading to closure of mines, necessitating import of cheaper mineral from global market. Fixation of the total levy on minerals in such a manner that not only the concern of all mineral rich, but the concerns of mineral deficient states are also taken care of, because the industries would be situated, core industries, which are using these minerals in other non-mineral states. So they get one particular mineral at one particular price and they don't start importing, or if some state decreases the royalty, they can even start exporting. Lord, I can face the contention that you remove you stop the export, but MMRDA is a one-time solution. That no, we will fix everything. So there is no difficulty in domestic production, domestic pricing vis-a-vis global pricing. Then,
Just-
9.
Just as you're fixing the rate of royalty, is it not possible, as the learned Chief Justice said, to have a ceiling or fix a rate of tax? The power to tax is with the states.
That is there.
But you can have a rate of tax or a ceiling on the tax to have uniformity
No.
with regard to taxes also.
Lord, constitutionally, it's going to be my submission that under entry 50, it says tax on mines and minerals subject to limitations imposed. This is the only entry where taxing power is denuded by the central law for mines and minerals if it is in public interest. My lord, the judicial inquiry would be, while examining entry 50, whether this is a tax by the state. Yes. Whether there is a law made by Parliament under entry 54 list 1 for regulation and development of minerals, and I'll show all these comes within development and regulation of minerals. And third, whether that law of Parliament is contrary to federal structure or is in public interest. I am showing not public interest right now. 8, my lord. To bring in uniformity in the structure of regulation and development of minerals and other aspects so as to make it an investor-friendly regime, incentivizing more investment in that mineral sector while balancing environmental concern as a holistic national level. The development of mineral industry needs uniformity at a national level, failing which fragmented state-wise levy will adversely impact the development of minerals and systemic utilization of minerals in larger public interest. The moment there is an act under entry 54 regulating and providing for development of minerals, that puts a limitation on the taxing power, apart from the specific limitation which I will show. But, my lord, my first respectful submission is that the architecture of the MMDRA, the rules framed thereunder, and the format, statutory formats, statutory formats in K, specimen K, not specimen, form K, Mr. Salve read one part of it, but I will read the other part of it, which specifically says that you are being given lease. And what is lease? Mineral is a national resource. It's owned by the people. Government is only a custodian, a trustee. In 5-judge bench, your lordships have accepted this principle in regarding natural resources, etc. What we are giving, by way of a lease, we means the state, right to extract, sell and appropriate the sale proceeds of something which is a national resource. In consideration of that, what is paid is royalty. And the way form K is couched says that this and nothing else. Royalty, rent, dead rent and rent, nothing else. That's the statutory contract one enters into when one takes the privilege of sharing the national wealth and appropriating it for commercial use, which is also necessary. I am not opposing that concept. Now, your lordships, kindly come to para 12, 8 means 9, PDF 9, my lords. I am skipping what is not necessary.
There is one thing.
My lords.
You may not skip,
My
Mr.
lords.
Solicitor General. Come to para 9,
My lords.
Roman 4.
Correct.
This seems to be the substratum, the heart and soul of your.
What your
principal
lordships would
argument,
answer.
Right.
Correct.
The only contention is the state's assertion that over and above the amount of royalty fixed by the central government with their active consultation, they can still independently impose levies, exercising its legislative competence under entry 50 list 2 of the 7th schedule. Your principal argument is that every penny of royalty goes to the state, no problem. My Lord Justice Oak pointed out subclause 3 of section 9 of the Act. Just give us some illustration, one or two. What are these? What is the nature of other levies which you are talking about over and above royalty?
It comes subsequent.
Oh, actually.
In pre-India cement era.
So one clarification.
Yes.
Is it your complaint that they are not adhering to Schedule 2, which fixes the rate of royalty? They may be strictly adhering to the price fixed in Schedule 2, but over and above those royalty,
Yes.
they are levying some other taxes.
Yes. And what they do is,
And your argument is that that is not permissible by virtue of Article 54.
read with 50.
Right? That's your argument.
Yes.
So what are these other levies which is impermissible for the state to impose?
Yes. Please, my lord, come to, my lord, I'll answer that first, my lord, and then come back to, my lord, my
Correct.
page 55, my lord, if your lordships can come. 55, my lord. Please see, my lord, para 93, just to immediately answer my lord's question, my lord Justice Patiwala.
Then you may proceed in your own way.
I'll come back to, my lord,
This
that, but
will give
yes,
us
yes,
some idea.
it's a, my lord, very pertinent question, my lord. And I also want to highlight this, my lord. This is all which is, it's a bone of contention, my lord, and it's not adversarial, my lord. Ultimately,
Para 55,
para 93, my lord.
page 55.
Yes, my lord. Page 55, yes. Para 93, my lord, your lordships get, your ladyship gets.
Got it.
Yes, I'll read. My lord, your ladyship gets.
Yes, sir.
Yes, sir.
55.
It is submitted that a decision permitting state to impose taxes on mineral rights would inevitably lead to a return to the scenario prevalent prior to India cement judgment. this would be contrary to public interest, etc. Now, 94. To get a sense of the scenario prior to India Cement, one may refer to the rates of cess or tax imposed by states at that time as derived from the report of the study group on revision of rates of, this is the source, published in March 90. The rates imposed were this, my lord. For example, the first state, cess at 25% of royalty.
Yes.
Then cess at 37% of royalty.
So it's a royalty plus the cess at 25%, which according to you is objectionable and not permissible.
Yes, ma'am. And Manoj, please see further. Mineral rights tax on coal at 300% of royalty. Well, today I can show after Kesoram, it's 500% in one state. I don't want to go into state versus center. Manoj. Then mineral rights tax on other minerals, 100% of royalty. Then please see the next state. Cess on iron ore at 300% of royalty. Then cess on limestone and pyrites at 200% of royalty. Cess on bauxite, china clay, dolomite and fire clay at 133.33% of royalty.
Therefore, Mr. Solicitor, now you have given us the building blocks of your argument by suggesting that, look, if the states are left untrammeled to impose taxes, what would be the impact? States will start imposing radically disproportionate taxes, variant taxes, so on. We've got that point. I think the heart of your matter really is, how do you read the MMDR Act? And you may be right, you can demonstrate that to us, because that's really the crux of the matter. How do you read the MMDR Act as imposing a limitation on the state power to tax under entry 54?
I get the Manoj. That's
Right?
the heart of the matter. As,
So you just spell out now those provisions of the MMDR Act which can be construed as limitations on the state power to tax, because that they also concede that the entry of the states, entry providing for taxes on mineral rights, is subject to the union power to impose limitations. Now the question is whether you have in fact as Parliament imposed the limitations, and which are those limitations. So you can spell out to us, and that really is the core of the matter.
May I come to that answer, Manoj, a little later, Manoj, 10 minutes later.
Right.
Before that, I want your lordships, Manoj, to see how, Manoj, section 9 is understood and how that consultative process has taken place. Manoj, it would be necessary, Manoj, before your
Which page of the submission?
But it's how, Manoj, section 9 has worked so far. And Manoj, I would also, Manoj, why I'm not immediately answering this question, Manoj, when MMRDA was enacted, there are parliamentary debates that we want to denuate the states from putting any other thing, any other levy. So therefore, Manoj, there is some chronology, Manoj, which I have conceived. Your lordships can take it from me. There are two types, Manoj, as I have earlier also said, that's person who have something to say and person who has to say something. But I would fall in first category. Your lordships can rest assured. But there is something new which, from the state's perspective, your lordships, sitting in this combination must know. That's all.
Yes.
Is it your argument that section 9 is exhaustive of all the levies which a state can
Yes.
impose
Yes.
on the right to mining?
Section 9 read with section 13, the rule making power, read with rule 31, read with, annexure F, the format. And that I will, connect. But before that, some history may be necessary, for some facts may be necessary. You must be doing it. my lord, please come to earnestly request your lordships to see the scheme of the act and the rules in the context of, my lord, what I am going to show, my lord. Please come to, my lord, page 112. My lord, I have produced, my lord, a report, my lord, and for only this, my lord, kindly allow me to use, my lord, the physical copy. There was some confusion at night, my lord, when I read. Some other report was annexed. Therefore, my lord, I have, my underlining is in the physical copy. My lord, I'll revert back to the digital copy, my lord. It's 113, my lords. And in this context, after this, my lord, showing this, I'll immediately come to the scheme.
Group for revision of rates.
Yes, my lord. Immediately, my lord, I'll come to the scheme. This is, my lord, a report of the study group for revision of rates. Please mark this, my lord. This exercise happens every 3 years, as per section 9(3). Your lordships.
The Solicitor General got away by saying, please permit me to use the hard copy. I do not know whether the bench members have that privilege or not.
Lord, I admit, my lord, I am technologically challenged.
No, I put myself in the same footing. And not only you and I, but I'm sure there are others also
Others
in the
also.
room.
No, my lord, but substantially we have shifted. No, what happened was at midnight, my lord, not midnight, 1 o'clock, when I was, my lord, marking my notes, my lord, so that I can give exact pagination, I found that the annexure, this annexure was wrongly put. It was another report which was put. So I could not, my lord.
We have the one by Dr. K. Rajeshwar Rao.
Yes.
Yes, my lord.
Same,
So,
right?
my lord, I had the hard copy, so I marked hard copy. Rest, my lord, is I am on the disk. My lord, please come to page 118. How, my lord, this is holistically and at a federal level considered. And, my lord, your lordships may note, this exercise has taken place every 3 years after the act was passed. Section 9, my lord, apropos, my lord, Justice Oak's query, my lords are right. Textually, it does not provide for consultation. But I must point out, when this act was enacted, some states in the parliament said that provide for a consultation, which was opposed by the government of the day, and consultation was not placed as a statutory provision. But it has always been read, and look at the level of consultation, which will give, my lord, I am not showing it for nothing, which will give the honorable bench, my lord, the idea why national level fixation of one price and what are the considerations which are going into it, which can never be done if it is fragmented state-wise imposition. That's the purpose of showing this. Please see, my lord, 118, the first para. The principles of, and my lord, kindly, my lord, bear with me, my lord, I'll go a little slowly so far as this report is concerned. The principles of royalty rest on an accepted legal and customary base. Minerals are non-renewable assets which, once removed, cannot be replenished. As owner of minerals, the state needs to be adequately compensated for the permanent loss of an asset thus depleted. Royalty, therefore, whether fixed as a share of profit from the mining industry or as a compensation for a depleting asset, is a consequence of ownership of an asset to which the title is transferred. Well, this is to answer whether it is a tax or not. Well, please come to page 119. Royalty regime in British India. But it has always been federal dominated for this reason, my lord. In the British regime, grant of mineral concessions were regulated by Government of India Act 1913. Subsequently, as per the Government of India Act 35, many constitutional changes were brought about under this act and minerals became provincial subject. As a consequence, the then provincial government of Assam, Bihar, Bombay and United Provinces framed their own rules for granting mining concessions. In 1939, the Government of India framed Mining Concession Rules 39 for regulating the grant of prospecting licenses and mining leases in centrally administered area. The Mining Concession Rules specified royalties on mica, petroleum and natural gas, oil, shell, gold and silver, iron ore and precious stones, and the rest of the minerals were not specified. The royalty was based on a specific percentage of the sale value in respect of specified minerals, except oil, shale, iron ore, gold, silver, and so and so. Now, present legislative provisions, your lordships can, my lord, consider skipping and come to chapter 2, my lord, page 121, my lords, para 2.4. Lord, I have marked it, my lord, so that I may not have to read what is not directly relevant. But your lordships can go through it, my lord, at leisure, my lord, if required. 2.4, your lordships have, my lord? 121. Or may I read? With a view to have comprehensive review of the royalty rates on all minerals in terms of its impact on production, mineral-based industries, export and the state revenues, for the first time in the year 1966, Union government set up a study group. This study group submitted its report in 1968 and recommended delinking of royalty rates from the pit's mouth value for most of the minerals and suggested unit of production, that is tonnage, as the basis because of the difficulties experienced by the states in administration of charging royalty as per value of minerals at the pit's mouth, which led to litigations and disputes. Subsequent study groups constituted in the year 73, 78, 84 and 89 retained the tonnage system. Please see 2.6, my lord. As a result of the adoption of the policy of economic liberalization and also as a sequel to International Roundtable Conference held in New Delhi in April 94, under the aegis of the UNDP, the Ministry of Mines constituted a study group in January 95 with a view to rationalize the rates of royalty to make them comparable with the international rates. Please, my lord, mark this. Lord, I am on entire act being read as a limitation and the act is in public interest, my lord. Please, my lord, allow me to proceed further. International rates and at the same time ensure rapid development of mining industry and augmentation of revenue earnings of the state governments. Lord, this is treated as a part of development of mining industry. This national level price fixation is treated as a part of development of mining industry, which is the act. Therefore, my lord, I say the act itself is a limitation. I'll point out the specific provisions also. And it also says that we want to augment the revenue of the states. So therefore, my lord, at the cost of repetition, I'm saying this is not a federal issue. State versus center. Yes, legislative competence of parliament versus legislative competence of state assembly, my lord, is an issue, but not a confrontational federal issue. My lord, then 2.9. My lord, ultimately, I'll, my lord, show that entire act occupies the field as a limitation to entry 50 list 2. That's, my lord, my attempt, my lord. That's why I'm going in a particular, my lord, chronology. 2.9, my lord, next page.
Extent provided.
Correct, my lord. Consequent to the notification of royalty rates in 2004, a high-level committee was set up under the chairmanship of Sri So-and-so, member planning commission to review the national mineral policy and recommend possible amendments in the MMDRA. The recommendations of the HLC in respect of royalty were as under. Please see only D and E, my lord. A lowering of rates to be considered only for such mineral for which there is evidence to show that the royalty rates are inhibiting mining operations and mineral production is registering a downward trend. They have studied and my lord recommended this, and these recommendations are the foundation for subsequent my lord fixation of royalties. The royalty rates of base metals, noble metals, and precious stones in which the country is grossly deficient needs to be low to encourage exploration for these minerals. But this also cannot be done fragmented way by the respective state governments, and the act, my lord, as I will show the architecture, acts as a limitation on any other taxing power. Then your lordships may, my lord, kindly turn the page and just 3 lines above para 2.11, PDF 124, 4 line, my lord. This schedule to the Mines and Mineral Development Act on an escalating scale, taking into consideration measures for effective deterrence against the mines, both the recommendations of this study group, the revised rates of the royalty, etc. Then 2.11. The period between 2007-11 witnessed significant development in the Indian mining sector, mineral sector. Based on the recommendations of HODA committee, Government of India in consultation with state governments replaced the national mineral policy with new national mineral policy on 13th March 2008. The national mineral policy provides for a change in the role of the central government and the state governments, particularly in relation to incentivizing the private sector investment in exploration and mining and ensuring level playing field and transparency in the grant of concession, etc. My lord. Now, please, my lord, turn the page over, my lord. Chapter 3. PDF 126, my lord. I'm sorry, my lord. Lord, there a global view is examined by the committee, and this is examined every time when there is a revision of royalty rates takes place. Lord, please come to last para 129, my lord, last 3 lines. Lord, these are all factors, my lord, which would lead credence to my argument subject to your lordship's, my lord, approval, that the act, architecture of the act and reading section 9, the way, my lord, the central government has read, operates as a limitation contemplated under entry 50. Lord, last 4 lines. It is evident, your lordship gets 129. It is evident that prevailing royalty rates in other countries are much lower than India and mainly in the range of 2.5% to 7.5% on ad valorem basis. For ease of comparison, 15 mineral-rich countries have been considered based on significant occurrence of the specific mineral. This is the examination which, my lord, is taking place every time there is a revision in fixation of mineral rates. Then, my lord, kindly come to next 130. And that is where, my lord, the government's concern comes, and that, my lord, would, my lord, possibly persuade your lordships to treat the act itself as a limitation, apart from 3 or 4 specific sections which I'll show. Because the act is, my lord, please bear in mind, providing for development and regulation of minerals. And once the field is occupied by provisions which makes the development possible and regulation possible, Lord, I will show some of the judgments. The regulation would also mean prohibiting taxation.
It could have been expressly provided under the act, a prohibition on taxation, but that is not there.
Lord,
Can we imply to
I'll
read
answer
into
that
this?
question straightway.
And
It is
second,
not provided.
it is not provided.
But, my Lord, no statute, my Lord, to my knowledge, would provide a negative provision that you, the state legislature, will not tax. It occupies the field, and the resultant constitutional effect is your power of tax is taken away. I will come to that, my lord, but I want your lordship and my lord, ladyship to see this. Then I am coming to, my lord, I'm aware. Whatever is the extent after section 2 is the extent of limitation.
Yes.
That's your, I bow down. That is the correct position. It's not that it's controlled everything, my lord, under the universe. My lord, it says whatever is.
What is beyond what is provided is the question now.
Correct. To answer that question, I'll have to necessarily go through this chronology.
Yes.
Whether, my lord, it is entirely your lordship's discretion to accept it or not, but your lordships must have, my lord, the background in which, my lord, your lordships are examining the question, because this is a 9-judge combination, and, my lord, the law laid down will have huge impact, my lord, on the economy of the nation, import-export policy of the nation, and the domestic production industry of the nation, because these are all used in core manufacturing and other domestic industries. And therefore, my lord, this was the position even when the constitution was framed. Therefore, only entry where taxing power is subject to some limitation. I know I have to answer limitation frowned where. I'll answer that. But please see, my lord. Section 9 has been, my lord, the consultation is read into it. Why, my lord, the state needs to impose any further levy for augmenting revenue? That is taken into consideration while fixing the royalty. To answer, my lord, her ladyship's query, my lord, again, putting it in a different way. There is no negative provision in the state, in my lord, the act, that state legislature is denuded of the power, because no legislative drafting would have such a provision. Negative provision is not required. How, my lord, that negative provision is
You're saying
ensured?
you are implied according to you.
No.
It's implied.
Lord, by occupying the field. Lord, if I am sitting on the chair, Mr. Dr. Singhvi cannot sit on this chair by occupying the.
We don't think that he will do that.
No, the question is,
Mr. Solicitor, we don't think that he will do that. He will even attempt to do that.
So, my lord, I don't have to, my lord, say that no, Dr. Singhvi will not sit in this chair. I occupy the chair. But look, that's my answer.
but the question is, what is beyond the chair? The chair is not exhaustive of everything.
That's what
There
I'm.
is something beyond the chair which
Lord,
is
it
not
is, Lord,
occupied.
I'll show, Lord. Lord, when the fixation takes place, everything beyond the chair is also taken into consideration. It is, my Lord, as my Lord the Chief Justice said, it's a block. It's all inclusive. Lord, MMRDA is a complete code in itself. When it provides for fixation of fiscal levy, it exhausts all fiscal levies. That is my respectful submission. Lord, please come to, my Lord, para 4.4. Lord, that is 131. And this is what, my Lord, would be the problem, my Lord, if India cement is to be disturbed, my Lord, and Kesoram is to be. I'm not worried about India cement or Kesoram. I'm before a larger bench, my Lord. Neither of the judgment binds. I'm sorry. Lord, 131, para 4.4. This is, my Lord, very crucial. Indian mining sector is carrying the burden of highest taxation in the world. The effective tax rate, for example, in case of iron ore, works out to be as high as 64% in case of the mines granted before 12 January 15 and 60% in case of the new mines granted after 11 January. My Lord, your Lordship knows in 2015, auction regime took place, my Lord. Otherwise, it used to be first come, first served, etc. Against this high incidence of taxation prevailing in the country, the internationally effective tax rate is in the range of 31% to 45%, as depicted in the table given at the end of the chapter. The mining sector in India is heavily taxed, and not only in comparison to international level, please mark this, but also in comparison to other domestic sectors.
Yes.
The taxation regime for mining in India affects all downstream industries and employment opportunities in the country, while fueling the already skewed balance of payment through additional import of minerals. Here, hence, there is a need to rationalize the taxation structure. No, they do not say royalty. They are rationalizing the taxation structure on minerals. Taxation structure for the mining sector for sustainable development and deriving long-term benefits in terms of sustained raw material security for the industries. We can't exhaust everything in 10 years, but our structure should be such that it competes with several factors. Then they have gone to effective tax rate, value of all amounts paid to the government. Please mark this, Malord. Kindly underline the word all, or. Value of all amounts paid to the government and divided by total revenue from mineral sales. Please, my Lord, come to the next page. My Lord, mainly, my Lord, they have given mineral producing countries and compared with Indian position. Mongolia is this 31.30% effective tax rate. Similarly, Canada, etc. Last two are India new mines, that is after 15, 59.84, and old mines, 63.97. This is the taxation structure as compared to global. And this includes everything which is payable to the government, including royalty. So they are deciding the fiscal structure, not royalty only, keeping in mind every fiscal levy which is permissible or impermissible. Except, my Lord, what is, my Lord, quoted in the at the bottom. ETR does not include a number of other payments such as auction price. Now after 2015, my Lord, I have to participate and I'll have to pay premium. Auction price, purchase of land for mining, GST at 18%, 10% tax levied by Supreme Court. It's a wrong word, not levied by levied under
Under the order.
under the judgment.
Judgment, that's right.
levied under the judgment of the Supreme Court, my lord, levied by the Supreme Court in Goa and Karnataka, and FDT levied by Karnataka, as well as highest rate of royalty on iron ore in Odisha. My lord, because they are imposing their own my lord, levies. Odisha and Karnataka are imposing their own levies. That is also considered. That is not considered still. Still, this is the high level of taxation. Net present value in case of survey in forest land, I am not going into details. Net present value is 4.38 lakhs to 10.43 lakhs per hectare, depending on density of forest at the time of grant of lease. Then compensatory afforestation, etc. Now, please come to the next page, my lord, where, my lord, the total fiscal payment is, my lord, decided. One of the main objectives of the study group as laid down in terms of reference is to review and suggest changes in the second schedule to the MMDRA. My lord, second schedule contains, my lord, the royalty. Regarding the royalty rates, keeping in view the objective of mineral development, please see. This is an exercise in the interest of mineral development, which is a field occupied by the central now. Because they are not only deciding what amount will get to which state, they are examining how the national development in the sector of minerals will take place. How would we regulate the mineral sector and mining sector in a fashion that it is developed? So this amount is, my lord, under the act providing for development of minerals. Then your lordship, my lord, kindly see 5.2. The study group had a series of meetings on so-and-so at Hyderabad for deliberating the methodology to be adopted, in-depth analysis of international and domestic demand-supply scenario, price trends of principal commodities, because they use raw material, my lord, minerals as raw materials, review of taxation and fiscal regime, please mark this, my lord, and fiscal regime, and engagement with all stakeholders to formulate the final recommendations of the study group. Well, this exercise is undertaken at the cost of repetition every 3 years or 4 years, whenever there is a revision in the fiscal regime. Then your lordship, my lord, kindly come to the next page, para 5.5. My lord, they prepared questionnaires, 2 questionnaires, one sent to, my lord, the affected parties, my lord, that is mining industry, and second to the state governments, so as to decide how the final figure is to be arrived at. Para 5.5. The questionnaires were also circulated for seeking information from the stakeholders with regard to the criteria for fixing rate of royalty, preference for ad valorem basis or tonnage basis for charging royalty or minerals, periodicity of revision of royalty, perception of the state government for the revenue earned for the imposition of royalty, utilization of royalty for infrastructure development, environment protection, guidelines on charging of royalty, guidelines for computing royalty on minerals on ad valorem basis, separate entry for so-and-so, so-and-so, so-and-so. Now kindly see, next page, new factors since last revision of royalty rates and dead rent, because 2015 regime, that is, the auction regime, steps in. After the notification of royalty rates and dead rent in September 2014, there have been major changes in the legal framework by way of effecting the MMRDA with effect from 12th January 15. As per the amendments, mining leases are to be granted through auction. Your lordships can, my lord, skip that, my lord. And, my lord, kindly come to the next page. Criteria for determining royalty rates. 5.9. Your lordship gets 5.9. In determining the royalty rates for minerals, the study group assessed the following parameters: grant of concession through auction mechanism and imposition of contribution to DMF plus NEMT, leading to hefty revenue generated for the states. Lord, kindly pause here for a minute. Now there is a new insertion, that is 9C, under which, my lord, every mining operator will have to pay 30% of the royalty to the state, my lord, which is being used for the purpose of mining affected persons and environment, not, my lord, for general welfare of the people. And, my lord, this national is, my lord, minimal, but that comes to the center. Then impact of high burden of taxation, especially in comparison to international mining jurisdictions. But this can never be done at the state level in a fragmented way. It has to be at the federal level. Then dependence on imports of minerals. Lord, sometimes what happens is, Lord, some mining leaseholders, they stop mining, which is required, my lord, for core industries as a raw material. So the country is dependent upon the import of the minerals. That is considered that we will have to fix the fiscal structure in such a way that import is minimum and we use the domestic production at the optimum. And my lord, the prices go high. Prices of the end product goes high. If we import the minerals to be used as a raw material, the end product in the core industry sector will go high. That is the concern, which can never be done at the state level. Then, my lord, sluggish growth of mineral sector and declining trends of its shares in country's GDP, trends in domestic production and export quantity and prices of mineral. There is, this is also considered that you are less incentivized to export your minerals and give it to your domestic users. Cost of mineral production, cost of transportation and handling charges, implication of revision of royalty rates on revenue realization of the state government and in the industry. Please see this, my lord. Unused stocks of low grade, etc. Your lordship can, my lord, skip. Next page, only two para, 5.12 and 5.13. One of the objectives of the study group is to devise a royalty regime which is effective, transparent, stable, and is attractive to the investors to invest in the mining sector, particularly for mineral like copper, gold, silver, and diamond. So they are using the word revenue, royalty, but they say that our attempt is to ensure that more and more investors come and that results in development of mines and minerals. Lord, that is the scheme, that is the architecture of the. Then view of the stakeholders. The study group has tried to obtain the view of stakeholders, etc. My lord. Now, my lord, may kindly see, I'm just giving, my lord, an overview of how my lord, this exercise progressed. Please come to page 138. Now, my lord, they take one mineral. View of the stakeholders. My lord, the first stakeholder for this particular mineral is Ministry of Steel. Can never happen, my lord, if it is fragmented state-wise. Please see. Was of the view that currently India has the highest rate of royalty on iron ore, that is 15% of average sale value amongst major iron ore producing countries, and thereby having highest taxes at 64% of effective tax rate. Ministry of Steel made the following recommendations. I am not going into it. My lord, then please see. B. Government of Andhra Pradesh. The main recommendation, please see beach send. Increase of royalty rate to 4% from existing 2% on ad valorem basis for limonite, sillimanite, so-and-so and so-and-so. They take into consideration what fiscal benefit we want to derive out of the mineral wealth which we have in our country. And therefore, they make a request and they give justifications. And acceptance and rejection of request are answered in this report with reasons. Please see, my lord. Then, my lord, please see next page, my lord. Government of Andhra Pradesh, my lord, iron ore. They, my lord, say this. Please see, my lord. Continue, my lord, 4. Your lordship have Roman 4.
Yes.
Continue existing rate of royalty for iron ore, 15% of average sale price on ad valorem basis, irrespective of the grade of the ore. They say we, our coffers would be enough if we get this much out of our mineral wealth. Then, my lord, they say that to introduce 2 new price slabs for the low-grade iron ore, etc. I'm not reading individually. I'm saying that every state represents, that you are deciding the fiscal receipt which my state will get. Please increase this, please bifurcate this, please decrease this, etc., etc. My lord, C is government of Chhattisgarh. I'm not reading. My lord, D is government of Gujarat. They have their own views. My lord, I'm not reading. E is government of Jharkhand. I'm not reading. These are just examples that every state participated per mineral. Look, this is an exercise per mineral, because every mineral has its own economic parameters, and every mineral will have different stakeholders contributing their suggestions. Then, my lord, please see F, government of Madhya Pradesh. The rate of royalty on diamond should be increased from 11.5% to 15%. They say that we want something more from our diamond deposits, because Madhya Pradesh seems to be a diamond rich state. Then government of Odisha, government of Telangana. Then, my lord, kindly come to my learned friend wants me to see, show to your lordship Telangana. It was highlighted by government of Telangana that the fixation of royalty should be based on unit or volume instead of ad valorem, mainly for adequacy, administrative efficiency, revenue stability, transparency, and simplicity in monitoring royalty collections and reconciliation. This is important. It was also pointed out that the present royalty regime, that is royalty, DMF, that is district fund and national fund, etc., imposes higher tax burden on mining sector and is high comparatively with other countries relating to effective tax rate. They say that decrease this, because internationally there is a low tax regime. We have higher tax. And their concern is they might lose the industries which are, my lord, using this particular mineral. So, my lord, they have their own, my lord, concern. Then, my lord, next is FIMI. FIMI is, my lord, Federation of Indian Mining Industries. So they have also participated, but I'm not reading it. But there, my lord, this is a stakeholder participation. Now, your lordships may, my lord, go by 1 or 2 examples of the minerals. My lord, page 148, para 6.4. This is how, my lord, the development and regulation of mineral is taken care of as a my lord, general architecture. 6.4. An analysis of the feedback given by the state government show that principal mineral producing state perceives royalty primarily as a source of revenue, as well as consideration for permitting exploitation of state mineral resources. These states are also of the view that royalty is a consideration due to the state government for allowing exploitation of its mineral resources, besides a tool of source of fund for local area and community development. They say whatever figures we are suggesting is for our development. It goes in consolidated funds of India. It's not for growth of mining industry only. It's their revenue generation. It's like income tax by the central government. It goes in the consolidated fund of India. This goes in the consolidated fund of the state. Then, my lord, the state governments in general gave priority for increasing the revenue earnings from royalty as criteria for fixing the rates of royalty. Further, the states sought to consider optimum utilization of low-grade mineral resources, fiscal measures for attracting investment. Please. I'm sorry, fiscal measures for attracting investment and mineral conservation as other important criteria for fixing royalty rates. Some states are also of the view that criteria of fixing the royalty should be to attract improved technology to bring royalty rates in tune with international rates for encouraging investment in mining sector. But they are saying that this is an all comprehensive package which we are deciding. FICCI recommends that differential rates of royalty should be charged on intermediate minerals, etc., etc. My lord, we are not concerned, my lord. Now, please see, my lord, one example. My lord, kindly come to, my lord, dead rent. And I'll again show, my lord, how this is a limitation. How this helps development and regulation. My lord, what is dead rent? Let us see conceptually, my lord, what is dead rent. My lord, I have a mine. I am not operating the mine for whatever reason. So I'll have to pay dead rent. That is the dead rent. My lord, why do we charge that as a concept? My lord, it's not merely, my lord, to incentivize the mine owner to continuously mine and produce minerals. There is one more important factor, my lord, and that important factor is this. Lord, your lordships are aware, my lord, the mineral resources of the country are limited. They will be depleted. And they are to be exploited in a phased manner. When I get the lease with a condition that I would extract minerals over a period of 10 years for sustainable development to ensure that simultaneously the ecology is not harmed, etc. Suppose I am greedy, or for whatever reason, my lord, there are some market forces, the price of that mineral has shot up. Instead of 10 years, I deploy more manpower, more machinery, and more equipments and do everything, my lord. If I have to extract 5,000 tons, I do it in 3 years. I would be harming the environment, I would be harming the sustainable development, and therefore for 7 years, my dead rent would be so high that I am disincentivized to do in 3 years. This is development of mineral. Therefore, I say the entire act is a consolidated, self-contained code for every aspect of development and regulation of mineral. But this, number two, but in the example which I have given, I'm sorry.
Yes.
Another, why dead rent and how it is directly linked with the development and regulation of mineral. Every section has this theme. Suppose I do something in 3 years, which I am supposed to do in 10 years, it would directly impact the price structures. Therefore, a provision for dead rent. Each and every provision has ultimate goal of development and regulation, but I am showing this to show that every state also comes before the government saying that this is the all-in-all package for my fiscal benefit, and this is how you decide the package. 58, my lord. So just, my lord, giving an example, how, my lord, now, my lord, this exercise is undertaken per mineral. This is not a general exercise. Per mineral, stakeholders are asked, stakeholders give their details, their desires. Global analysis. Now for bauxite, after considering each state's request for increase, decrease, change in methodology, etc., the central committee goes into the global analysis. Aluminum industry is the principal consumer of bauxite. World production of aluminum was 58 million tons in 2015. China continued to be the leading producer with a share of about 54%, which is followed by Russia Canada, and UAE and India, 4% each. Global aluminum demand of so and so, but I am not reading everything, but they examine the global scenario qua bauxite, keeping in mind the demand, request, or desire of every state government for their generation of fiscal revenue. And 163 is the conclusion. Yes, my lord. Kindly see, my lord. Keeping in view the global consumption production trend, analysis of global royalty rates, increase in production cost, and future domestic demand. Look, kindly see the parameters they are considering. This can be considered only at the national level. That production cost has gone high, future domestic demand. The study group recommends that royalty rate for metallurgical grade bauxite be reduced to 0.45% of LME prices so that net impact including DMF and NMET remains same as 6.60%. Please mark net impact including two statutory levies under the MMDR. I hope, my lord, I am able to, my lord, make myself clear. But these two, DMF is, my lord, fund created under 9C and NMET is a fund created under 9D. So they say royalty, DMF and any NMET, considering that the net impact is only 0.60%. And net impact would mean whatever you wanted is given or not given for a reason, but you cannot levy anything more. Constitutionally, I will answer how can we say that. But this is how the exercise takes place. So just, my lord, by 194, my lord. So just, my lord, I will not read this. I can assure your lordship I will not read this. But for limestone, impose cess, etc., which is not a tax. And royalty in any case is not a tax. That's not, my lord, the issue I am right now, my lord, raising. So please see limestone, my lord, at page 194, 193. My lord. I'm not reading it, my lord. But every state had different justifications, my lord, for increase, decrease. But eventually, the committee, after taking into consideration everything, my lord, at page 194, 85, 194.
And the manganese 80%, 83.
Your lordship may see the bottom. Then I'm through. I'm done with this. After analysis of data on cement price for the last 3 years, impact of limestone as raw material cost and its significance for infrastructural growth, the study group recommends to adjust royalty rate of LD grade limestone to rupees 70 from rupees 90 per ton and other grade limestone to rupees 60 from 80 per ton, so that the impact of DMF and NMET gets cushioned and absorbed for auctioned mines only, meaning thereby only 3 levies are being contemplated. The reason is this, my lord. limestone is directly used, my lord, for manufacturing of cement, and cement is required for the core infrastructural growth of the country. What they say is we will have to cushion these two charges, meaning thereby it's very clear that they are providing for a all-inclusive fiscal benefit to each state.
Are the states told by the study group at any point that, look, in lieu of your taxing revenue, what is it that you require by way of total revenues to be generated, so that we will take royalty, fixed royalty, take into account your overall loss of taxing revenues? Does that exercise happen? We find only that they have said, well, to cushion the payment of DMF and NMET, the reduction of rates of royalty in certain cases has been recommended. Because after the 2015 amendment, they have to pay to the National Mineral, the District Mineral Fund and the Exploration
state,
Trust.
yes, district fund.
Right, but is there anything here to indicate that the states are told that, well, what is it that your revenue generation requirements are?
No,
and
not
therefore, when we
only
fix the royalty, we will take into account your loss of tax revenues.
I get that. Lord, my questionnaire, questionnaire which is sent to the government, state governments. Lord, page 148, if your lordships can come to, my lords. Para 6.4.
You're right that throughout the study report, the study group's report, they keep on saying that, look, we have to cushion the impact of the DMF and the NMET.
Meaning
But is
thereby
that
doing
really
more.
right? Therefore, you are because of the DMF, the states are getting this additional levy. The industry has to pay extra, so that we will cushion that impact by reducing the rate of royalty.
So, meaning thereby nothing else. Otherwise, my lord, there is no question of cushioning. My lord, even they are going to the extent.
Nothing else is the key. See, where do you get that actually?
I'll, my lord, come to that. But lord, just answering your lordship's question.
Because we saw that
if your
everywhere they are
lordship
saying to
looking
cushion
at-
the impact of DMF, NMET.
Lord, if your lordships are looking at a specific negatively worded provision, there is none. That nothing else, this and nothing else, because legislature do not use such language, my lord, for another legislation, a negative language. They occupy the field, and I'll show the field is occupied.
Only to the extent provided.
Exactly.
In the
I'll
section-
show the extent. Your ladyship is right. I'll show to what extent it is provided.
In fact, the provision appears to be
Yes,
to
I'm
compute
sorry.
the effective rate of tax. The effective rate of tax is the total amount which is paid to the state, divided by way of royalty and other levies, divided by the total realizations on account of sale. Then they say that the effective rate of tax is very high in India, and therefore perhaps the royalty rates have to be so modulated.
That would, in my submission, necessarily mean that if you put any other burden, the balance at the national and international level will be disturbed. That's the only similar. Answering, my lord, the Chief Justice's query, Lord, please come to PDF 136. Criteria for determining royalty rates. Lordship gets it, my lord. Your Lordship gets, my lord. Can I read? My lord, kindly come to F and G. F. My lord, I'm not reading the rest.
But see, B, for instance, impact of high burden of
Yeah.
taxation,
So-
especially in comparison to international mining jurisdictions. So
Yeah.
does this not really therefore seem to contemplate that there is a duty to pay tax to the states? The burden is high,
No, no.
and therefore we are fixing the royalty to modulate the burden of taxation.
No, no. My lord, the impact of high burden of taxation would mean that as per the global phenomena, our fiscal regime, my lord, use a general, use a neutral word, that our fiscal regime has high taxation. But therefore, my lord, I had shown to your lordships what it includes and what it doesn't include. My lord, please for a second, my lord, just to answer, my lord, come back to, my lord, that high taxation
No, no,
part.
query
Value of,
Mr. SG, query of
Means that there is.
Honorable Chief Justice was,
yes,
very fact that clause B refers to high burden of taxation.
yes, my lord.
It itself contemplates that states will continue to levy taxes.
My lord, I am
That will be
answering.
taken into consideration while fixing the royalty.
Correct, my lord. I am answering that.
Right.
My lord, please come to 19. 132, my lord. 131, I'm sorry. 131.
As you rightly said,
May I answer that, my lord, possibly?
Royalty, though fixed by the union, is entirely appropriated, levied and appropriated by the states,
Correct.
right? Now, therefore, when they are fixing royalty, they are fixing the price which the states will realize for the extraction of minerals of which they are owners, right? That's the whole concept of royalty. Also of dead rent, that because you don't extract, you have to pay dead rent. Now, while fixing the royalty, which is a realization by the states for the extraction of minerals, the study group looks at what the state is already realizing on account of taxation. And it in fact says that because there is such a high burden of taxation which the states are imposing, therefore we will modulate the royalty accordingly, which postulates again that taxation is something which the states are imposing. In fact, it's not the other way, that look, we are increasing the rate of royalty to a level so that you will exclude all other levies.
Can I
That's
answer
not the
that?
approach
Can I
of the
answer
study
that?
group.
But there is an answer. There are two answers. Please come to, my lord, page 131 at the foot. 131.
Nor are they fixing royalty to compensate for the loss of tax revenues.
It's there, my
it's
lord.
the
I'm
reverse.
showing that. I'm showing that. My lord, if your
Page-
lordship can just bear with me. Page 131.
131.
131. My lord, how, my lord, the effective tax rate is calculated? 131 bottom. Lordship gets, my lord?
Yes.
Value of all amounts paid to the government by the miner.
Mr. Solicitor,
Only a minute.
this goes against you.
No.
If effective rate, if the numerator in the effective rate of tax were to be the value of all amounts paid to the government on account of royalty,
No.
then you would be right.
No. Kindly, my lord, kindly, my
When
lord,
they
give me.
they factor in all payments which are made to the state.
We try and read, my lord, it that way, but kindly read it other way. That everything which the.
And because
No, one thing is clear.
because the product of this division, the numerator and the denominator, is so high in the case of India, almost 60%. Therefore, they wanted to impose a more realistic royalty regime by, in fact, reducing the rate of royalty.
Can I answer that one? Can I answer? Oh, first and foremost, when this report is prepared, Kesorami holds the field, and therefore there were levies. There are levies. So that cannot be ignored by the study group. Correct, my lords? After Kesoram, the state is imposing levies in some my lord, states. It's 500% of that of the royalty. So it says value of all amounts paid to the government. Please, my lord, now turn the page. That would get, my lord, the answer, my lord, of what my lord, the Chief Justice, my lord, put.
India 59 and 60.
59 and, my lord, that's okay. But note, what it does not include. First, he said everything which is paid to the government. But except this, my lord, please see, ETR, that is effective tax rate, does not include a number of other payments such as auction price, purchase of land for mining, GST of 18%, 10% tax levied by the Supreme Court, net present value in case of survey, net present value, compensatory afforestation, upfront payment at the time of grant of mining lease.
But it therefore does not include, it does not exclude the state cesses. It includes the state cesses.
That's exactly
Right?
what
You
I'm
may be
saying.
right, it's because of the prevalence of Kesoram, because when the study report came, we were in the Kesoram regime.
Yes.
Where the states can levy cess. But the fact remains that this study group postulates that the rate of royalty would be so modulated so that the amount which is realized by the states towards royalty is adequately reduced to factor in the high rate of taxes which the states are otherwise imposing.
My lord, would your lordships come to a 2-page thereafter, my lord? 5.9, para 5.9.
Methodologically, the study group is not saying that, look, we are now going to give you an adequate realization by way of royalty so that you do not impose any other levies. That's not what they are telling the states.
On the other hand, this
136, if your
this
lordship comes.
exclusion clearly states that there are other types of exactions
Right.
which the states can do. For example, in Karnataka, forest development tax or FDT is levied on forest produce, which also includes mineral resources.
That is the question, my lord, whether it can be levied or not. That's the question. Whether it can be levied. But that's the question. It is levied. My lord, in every state, under some name or the other, it is being levied. But, my lord, my reading of, my lord, this page 131 is that how tax rate is my lord, derived, all whatever you are supposed to pay, state tax, royalty, district fund, national fund, everything, multiplied by this, except A, B, C, D, E, which does not in the exceptions or deductions do not take care of state. And apropos your lordship's query, my lord, please come to page 136, whether it is considered or not, that what is your revenue requirement. Point G, my lord, I stopped, my lord, at 5F, but please see G. Implication of revision of royalty rates on revenue realization of the state government and the industry. This is inclusive.
From royalty. That's right.
But if, my lord, if we, Lord, there are always two ways of reading it, my lord. But, my lord, what they say is that what will be the implication on the overall growth of, my lord, this sector and how it would impact. My lord, if I don't, my lord, wish to take your lordship through every mineral, my lord, wise discussion, what they say is this is the total amount which a miner pay. This mineral is used in ABCD industry. This is the position in the global market. And if we do not put the cap of total fiscal payment at particular point, it would be against the development of the mining industry. That is how, my lord, they have proceeded. Well, the difficulty for me is
states were compensated through
Lord, after, Lord, Lord, I'll come to the act immediately.
B.
Lord,
B and G also.
Lord, after, Lord, I'll come to the act immediately. But apropos this query, my lord, after India Cement, when the state was not permitted, my lord, to levy anything other than royalty, they were compensated by the respective study group by increasing royalty. So it is always considered as a composite receipt by the state. Lord, please, my lord, come to volume 5, only one paragraph, page 1569. Lord, this is a Mahalakshmi judgment. State of MP versus Mahalakshmi Fabrics. So when you are not levying the other charges, you are compensated.
Volume 5, right?
Yes, my lord. Volume 5, page 1569. It starts at 1561, my lord, but I am pointedly inviting your lordship's attention to the relevant part. PDF is 1575. I'm sorry, 1575. 1575. Left side PDF.
1567.
One five.
The Lordship gets, my lord. Left hand side, my lord, pagination 1575. PDF pagination. My lords, my lord, get it, my lords?
Yes.
The Lord, first, the controversy ultimately came to be decided by this court in Orissa Cement versus State of Orissa, whereby such cess was held to be invalid and beyond the legislative competence of the state government. It appears that soon after the aforesaid invalidation of the cess, the coal producing states were faced with problem of refunding the amounts obtained by them that far. They therefore approached the central government for help. In pursuance to the said approach, Parliament passed an act validating the cess so that they don't have to repay it to the government, repay it to the miners. We are not concerned. We are not concerned with the said ordinance and subsequent act in the present proceedings. It appears, please note this, that since the state government had suffered financial losses because of the invalidation of cess, they also approached the central government for help in the matter. As a consequence thereof, a working group was constituted in this behalf. The said working group suggested an increase in the royalty to the extent of 17% per ton of coal. The working group also found sufficient justification for compensating the coal producing states to the extent of 100% of the loss caused by the aforesaid judgment of this court. Since the recommendation was accepted by the central government, the impugned notification was issued by the government. According to the writ petitioner before the High Court, the increase in the rates of royalty pursuant to the notification was to the extent of 400% to 2000% as compared to the royalty fixed in 1981 on various varieties of coal. It was further contended, etc. My lord, the point I'm making is when they were prevented from taking any levy, that loss was compensated in the fixation of royalty. And when they are, my lord, now permitted to levy because of Keshav and subject to what your lordship decides, lord, the royalty is so fixed that it also takes into account that you are already earning this much. Because this subgroup, my lord, cannot sit in appeal whether it is leviable or not. They will have to proceed that as on date it is leviable. You are earning 100 rupees.
In other words, the fixation of royalty is not agnostic to what the states are realizing by way of taxation.
Because of Keshav, yes. Yes. Yes, therefore, my lord, therefore this reference.
It doesn't that the states are entitled to demand something by way of tax and they adjust the royalty every 3 years.
Now, my lord, what would happen, in practical terms, what would happen? If your lordships hypothetically were to hold that the state had no jurisdiction, competence, state legislature had no competence to levy a particular levy other than royalty, dead rent, and my lord,
You are saying that the government of India will increase the royalties. If you are,
because that will somewhere we will have to have a national perspective. Lord, we will have to have national perspective, keeping in mind the global scenario, and this exercise cannot be left to the provincial interest. Narrow provincial interest. Narrow, I'm not using it in a bad sense, but when I'm deciding for one particular state, my lord, my examination would be a narrow examination. I would not take a holistic national approach, and in any case, I cannot take global factors into consideration.
side. See, if a state is so foolish as to impose a tax at such high rates, obviously the market will provide for greater imports.
Yes.
If there is a greater amount of imports, the states will lose their revenue because there will be no demand for locally produced minerals.
My lord, the nation loses, my lord, when import increases,
Right.
that's exactly what, my lord, I am driving at. That if the domestic production is less because of high taxation, the import starts. That's what we are, my lord, avoiding.
but the-
We want,
but
only
the
give me a
state-
minute, my
The
lord.
state will never want to be in a situation where by overpricing overtaxing the product, starts losing its revenues. Because if it overprices the product, it's also a matter for demand and supply for the state. If it overprices the
It has
tax
happened.
rates, if it overcharges, then obviously there'll be a greater incentive to import, as you're rightly saying. In which case, it will impact upon the state revenues.
My lord, what, my lord, sometimes they, suppose they, or they undercharge it. They undercharge it and start exporting. Lord, the idea is that national level, on the national level, a holistic decision is taken that our minerals, which are our national resource, are used for domestic production of infrastructure and core industries. And therefore, this is one way of controlling import or export.
Just one, what you are trying to show is exercise done once.
No, every 3 years it is done.
Yeah, it's very slightly different.
I'm sorry.
We are not considering how the royalty is being fixed by the central government. We are considering only a very simple issue, whether power to impose royalty is itself sufficient to draw an inference that states are denuded from the power under.
Please come to
50.
the act, my lord.
And
Please come to them. I know, my lord, that's the heart.
Because suppose in a given case, tomorrow central government says that we want to impose royalty of say only 10 rupees. They have power to impose royalty of 10 rupees. So can you say that the states can't levy the tax? In a given fact situation for a particular year, the government may have undertaken this exercise of talking to the states, taking their feedback. We are really on the question whether only because there is a power to levy royalty, the power of the states to take taxes is.
I'm answering that immediately. Factually,
Right.
look, this is not a one-time exercise. This is an exercise done whenever there is a revision of royalty. That is every 3 years, sometimes for not 5 years. So this is how the section 9 is read. The consultation is read into section 9. That is one. The consultation with the state to arrive at a consolidated figure is read into. Now please see section.
It's public interest. The market force doesn't happen.
Metaphorically, just taking from what Brother Oak was.
My lord, my respectful submission, giving, my lord, taking the example, my lord, metaphorically as your lordships are taking.
For example,
If my, yes, sir. My lord, if my intention is to occupy it exclusively, then he is ousted. My lord, apropos my lord's concern, and a very valid concern, that market forces can itself arrive at a particular decision making. For example, your lordship said, give me a minute, my lord, to answer, that state if overcharges, then state would not get the revenue and therefore market forces would ultimately, my lord, settle down the issue. But that takes a very long time. When we rely upon market forces to settle down an issue, the damage is done. And this is damage about our national resources, and damage would be national level. My lord, the mistake would be, or whatever decision would be of a state. My lord, your lordships are examining this as a federal issue.
To use Brother Rishikesh Roy's example, your submission is that, look, because I'm occupying my chair, Dr. Singhvi is ousted from occupying his chair.
No.
Go ahead,
I'm
sir.
sorry, my lord, I'm sorry. Only a minute.
That's why I said what lies.
No. I'm sorry, my lord.
That is why I said what lies.
My lord,
beyond
I would answer, my lord. My submission is, there is only one chair in the room, which I am occupying with an intention of ensuring that nobody else, including Dr. Singhvi, occupies the chair. There are no two chairs here. Your lordship, my lord, example presupposes two chairs. I am saying, my lord, there is entry 54. 50 says, if there is a law under 50, you are out. So there is a law under 50, the field is occupied. And there is only one field. That is mineral development and regulation and development of minerals. So, my lord, my metaphoric example was when there is only one chair and I occupy the chair with an intention of excluding others. And I am giving, my lord, why I gave all this, my lord, because I have to show public interest. It's not, my lord, just that state center wants to act like a big brother. There is a public interest involved, my lord, as 54, entry 54 stipulates. My law is not just, my lord, for development and regulation. To oust or to be treated as a limitation, it must be in public interest also. That's what I was showing. That why this has to be done at a national level and not at provincial level with some narrow, my lord, considerations weighing. And your lordships are right, my lord. Sometimes a wrong decision by a state to overprice may damage the state, and after 3-4 years, the state may come down. But what happens within that 3-4 years? That's the question, my lord, which will have to be asked.
See, one other perspective is, in the context of royalty, the Central Act or the Parliament is permitting the states to levy royalty. But what is the limitation imposed on
No,
the?
not levy.
No.
Parliament
they are
doesn't
collect-
permit me
no,
to levy.
the state is levying the royalty under the Central Act.
No, my lord. What
It's not the center which is levying the royalty.
I am only fixing the rate.
Correct. That is the only limitation on the right.
No. My lord, my
fixing of
submission
the
is, now examine that submission. Examine that submission. My submission is,
Royalty, the states are.
state,
So Parliament is enabling the states to collect royalty,
yes, not,
but the
yes,
limitation is only on the rate of royalty.
correct.
So that is a constitutional limitation in the context of entry.
That is their submission that the
No, no.
on,
Under the act.
that's, my lord, I have to yet, my lord, convince your ladyship. But their submission is that section 9 is the only limitation, and since section 9 does not prohibit other levy, we can have law providing for other levy. But that submission is wrong, my lord. That's what, my lord, that's the main dispute.
Yeah, you are going to go to the act now, I suppose.
Yes, kindly, my lord. My lord, kindly come to the statement of objection reasons. The differentiation made between petroleum and other minerals in item 53 and 54 of the union list has rendered separate enactments for the two necessary. The present bill deals only with minerals other than petroleum. At present, both are dealt with under the mines and minerals, my lord, that is the old act. In my lord, your lordships can skip, my lord, nothing would turn. Come to, my lord, the preamble. An act to provide for what, my lord? Development and regulation of mines and minerals under the control of the union. So the act provides that the entire act take within its control the development and regulation. Whatever is necessary for development and regulation of mine is now under our control. Your ladyship is right. Section 2 says to the extent below. I am conscious of it. 2. Declaration as to expediency of the union control. It is hereby declared that it is expedient in public interest, to borrow, my lord, expression from entry 54, that union should take under its control the regulation of mines and the development of minerals to the extent hereinafter provided. Now, my lord, it provides for three things.
Yes.
Lord, first is reconnaissance. Lord, I want to, Lord, show that entire universe, so far as mineral regulation and development is concerned, is now covered by this, and therefore there is an occupied field. Lord, reconnaissance would mean without touching the soil by, Lord, satellite imaging or whatever, one would first decide whether there is any mineral in the land. Second would be prospecting of mineral. So there is a prospecting license regime where you excavate just to find out whether there is any mineral. Sometimes you are trying to find out a mineral and you find B mineral. There is a provision made, then you have to surrender your lease and give it to the government back if, my lord, instead of uranium, my lord, something else is found. And third is actual mining. All these three. There are two separate chapters under the Act, one dealing with regulation of mines and another dealing with development of mines. And my respectful submission would be that these two chapters, read with other provisions, Lord, I started with the Act, my lord. Can I start after lunch, my lord? It's 5 minutes. So that one continuity, my lord, your lordship can be.
How long would you now take, Mr. Solicitor?
Lord, one more session, less than that, my lord. But I'll,
We have given 1 day for everybody to conclude, actually.
my lord, we have relied upon your lordship's kindness.
All right.
And
But I think
there is a
everybody should
rule of estoppel.
Everybody should conclude by lunch tomorrow. I think that will be a very fair, isn't it? By
Lord,
lunch tomorrow, everybody
Lord,
now.
we rely.
By tomorrow. We have to close tomorrow
Lord.
because we have regular.
Lord, I would say something. Lord, we are before a 9 judges bench. Any lacuna on our part in assistance, Lord, एक minute. Even for the other side, Lord, I would request that if there are two counsels, let both give this.
And one more thing, I am going to be doing without prejudice alternative arguments. Your lordship accepts these arguments, the matter ends.
But
Your lordship doesn't accept.
Lord, your lordships would,
Not going to
Lord, Lord, what your lordships would, my lord, give it to me.
After now, the Solicitor General concludes. I think everybody can take 20 minutes each, and then.
Lord,
because it's
Lord, I would invoke, Lord, I
more of
would.
a good thing now, I think.
Lord, I would invoke the doctrine of legitimate expectation and estoppel. Your lordships cannot cease to be kind.